Good afternoon. I'm Dr. Sarah Smucker-Barnwell, and I'm delighted that you're able to join us today for our 25th Telehealth Community Chat. Thank you for being here. As a trust policy holder, you're probably familiar with the Telehealth Community Chats if you're here today. I'm pleased once again to be joined by Dr. Margot Adams-Larson to present our 25th edition in this series. Without further ado, let's get started. Welcome, Margot. Thanks for being here.
So great. This is always my favorite time of the quarter to chat with you. And just as a quick reminder, we're here to really bring in conversations about ethical, clinical decision-making relevant to telehealth. We don't have slides because we don't always know what we're going to end up chatting about. Because we're looking to the questions that you're putting in the Q&A as we're going along. So as Sarah mentioned, we've got some slides that you can grab from the links related to some of the acronyms, and we will do our best to review through those as we go. But I'm so glad you're here, Sarah.
Well, thanks so much. This is great. And we're kicking off with our telehealth news because we like to get into what's happened in the last quarter since we last spoke. And I wanted to start off, I asked Margot if I could do this one specifically because it's near and dear to my heart. At the recent APA convention in my hometown of Seattle, Washington, the APA Council approved a statement, psychology's impact on artificial intelligence. Excuse me, an APA statement about artificial intelligence. I should note that this one passed pretty overwhelmingly. I believe the vote was something like 156-2 with only one abstention. I mean, that's a pretty, as these things go, that's pretty darn popular. I just want to take a moment to mention a few items that are included in it. I encourage you to check out that statement on APA's website if you're interested. But essentially, it reviews psychology's impact on AI and AI's impact on psychology, including how psychology helps shape AI's societal impact, the potential there for us to be participating in that, AI's promotion of health and wellness in our society, ethics and privacy in the context of using AI and psychologists using AI, of course, and also just had a series of helpful process recommendations and reminders around best practices. I encountered the information as pretty darn sensible and frankly pretty centrist because I know AI can be really provocative. Folks can have really, pretty dramatic opinions. This one I felt was pretty middle of the road accessible. So I think pretty helpful. So encourage folks to check it out. And it's a nice reminder to check out our upcoming webinar partnered with ABEP on AI and psychology.
Fantastic. And I have a couple updates or items to be thinking about that came through, I think mostly in the news, but there is a new requirement for those of us who have LLCs or other business entities related to healthcare. And it's a federal BOI filing requirement for healthcare entities. And what this means is beneficial ownership information report. And it's a super simple thing to click and do. You might have heard about this from your accountant if you have one, or a colleague if they're keeping you in the news, but it is a new requirement under the Corporate Transparency Act for US businesses. And basically, this is designed to provide information about business ownership to help combat financial crimes. So if you Google it, you will find information about it. If you need more details as to where to go to fill out the form, you can ask your accountant, or you can also find that online. But this really is a news item to say by January 1st, this is something you will need to do. So heads up, go get more information on that. A second item that we wanted to bring up was just maybe more so about an emphasis on perhaps why it's good to have diversification within the tools that we have within our businesses, within our practices. And the Microsoft CrowdStrike fiasco, I'll call it that, that has occurred and kind of come through a number of other channels of disrupting businesses really brought to light some conversation that Sarah and I had in the past couple weeks. Even the Verizon outages have really emphasized the importance for all of us to have backups in terms of our systems, diversification in terms of what we're using for our tools and practice in case something goes awry. Maybe your cell service is out, maybe your Wi-Fi is out. How are you going to conduct business? Maybe Microsoft goes down for the day and now you don't have your calendar or a few other essential items that you may need. So thinking through just not relying on one key thing, but having some backup or secondary systems in place in order to conduct your business of your practice. So just a couple things that came up in the news that are somewhat relevant to what we're doing in terms of our practice. And so I know, Sarah, you have some other really big news too that is worth its own segment. So I'll toss it.
Well, I have one more small news item, which I meant to mention earlier, actually, and it's hyper local news for the telehealth community chats. And that is, and someone mentioned this in the Q&A, that in the beginning of 2025, there will be a $15 fee per CE charged for the live telehealth community chat. So these chats, we want to make sure folks knew about that well in advance. So this matches the rate for other on-demand chats. All the live webinars, such as risk management roundtables and the cultural competency forums, will remain free for policyholders, but this change is coming up in 2025. So that's our super local news. On the other news that gets its own segment, as you said, was about we have new telepsychology guidelines. So I had the pleasure of meeting Dr. Margot Adams-Larson when she and I served together on the original Joint Telepsychology Guidelines Committee, which had membership from APA, ASPPB, and the Trust. And those guidelines were adopted in 2013, and they expired 10 years later in 2023. And I'm very proud to have the opportunity to chair the working group that revised these guidelines. These revisions passed APA Council this past August at the APA convention in Seattle, Washington, which I thought was very polite for APA to have its convention in Seattle when we had to present those guidelines. Super nice of them. I might not have been part of the decision, but I liked it. And again, we were very happy to see, as I said with the AI statement, so too for the telepsychology guidelines. It was mercifully a pretty overwhelmingly positive vote and very little, very little contentious discourse or disagreement around it. So I wanted to give a little bit of a review about what we can see upcoming in these new guidelines. Encourage everyone, just this past week, the new guidelines are available on APA's website. So check it out to take a look at it if you'd like. But just want to give you a little bit of a review of why they were revised and the types of changes we can anticipate showing up. So just a review of the process. This past decade, as we all know, saw tremendous change in telehealth technology, in the adoption of telehealth expedited through COVID, and just an emerging regulatory landscape that supports telepsychology vis-a-vis SIPACT. So much had changed from 2013 to the time when they expired in 2023. But I think there was an appetite to further ensure that psychologists felt that it was appropriate to revise these guidelines. So at that time, APA staff facilitated outreach to membership, soliciting feedback regarding the necessity of an update to those guidelines. And the response to that was a pretty resounding yes. The themes that emerged were that psychologists shared they wanted to see an update to reflect evolving best practices. What was best practice in 2013 was not necessarily best practice in 2023. And they wanted some flexible, durable guidance in a changing landscape. Also, a lot of feedback regarding ensuring that we're addressing and making efforts to highlight diversity, equity, inclusion, and belonging in telepsychology, because I think many of us who started off in this work saw this as a mechanism, a tool to really advance access to evidence-based care. And the emerging data that we're seeing is that is not happening. As we talked about in previous chats, the gaps have widened instead of closed in the past 10 years. And, we need to do better. So I think there was a call to highlight this in the revision of those guidelines. So APA put together a working group that comprised of membership, and it mostly included telehealth subject matter experts from diverse personal and professional backgrounds. Had folks from BPA, from COPS, from ASPPB, from different organizations within psychology that kind of think about different facets of the profession. And this group came together and looked at those 8 original telepsychology guidelines and essentially did some revision, some condensing, and some expansion. So I'm going to talk a little bit about what changes you can see. So first of all, the revisions. Several of the guidelines, guideline 1, which used to be competence, a guideline on informed consent, guideline on data management, guideline on interjurisdictional practice, and best practices, which we used to call standards of care, but now we're calling best practices, as well as testing and assessment. In each of these instances, we sought to include updated information born out of a now more robust extant literature, just expanded understanding of regulatory information, and a lot of practical information, how-tos of how practice has evolved. So, what you'll see when you go look at that document is just kind of some revision of some of those oldie but goodie guidelines. There was one area where we did some condensing, and that was in the confidentiality of data and security and transmission of data. I think technology advanced to a place, and our understanding of some of these things advanced to a place where we could more concisely combine these elegantly now. So we tried to make things a little more succinct, easy, accessible, user-friendly. And there were some new areas that we expanded the guidelines. So we now have some additional guidelines that were not included in those original 8 that the working group believe now merited discussion and inclusion. So these include a guideline on documentation. What do you want to document in your telepsychology practice? Emergencies, how to handle those remote emergencies, supervision and training, because goodness knows, especially in COVID, a lot of us, really explored what is it to provide supervision, what is it to receive training, at a distance, and emerging technologies, which is, a little obtuse, but ultimately an idea of what durable guidance can we offer to acknowledge and address just an ever-evolving landscape. What are the durable considerations? Even though, because I don't know what tomorrow's technology will be precisely, but what are the themes that I should be thinking about evaluating as a psychologist using technology? So we had a public comment. Folks went through and they gave us our feedback, and the working group responded to that. We actually, when we went to submit the guidelines, had some friendly amendments. But frankly, they're all there for you now. So, I'm sure that in the coming days, there'll be lots of information about these new guidelines as we want them, but I encourage everybody, if you have a telepsychology practice, I'm hoping so, if you're here at the telehealth community chats, take a look at those new guidelines and think about, what they might mean to your practice.
Sarah, we've got a common theme coming in the questions as to where to find the link for the APA guidelines. Do you have a quick reference for us in terms of, I'm guessing, on the APA website? So
yeah, on the APA website, I will gladly put that in the chat for us.
The one common theme that I am already deducing today is Google will find a number of these things for us, but I know folks like the official reference location. So what I'm loving about this is the updates are kind of bringing in line some of the things that we've experienced in practice over the past 5 years, so to speak, but also there's not a significant amount of change in terms of what was there prior. And so I feel like early on, we've done a fair job of being consistent and having some ideas as to what we needed to look to. And I love the idea of some condensing of things that we're able to streamline now into a more succinct flow for folks. So I think overall, they're very readable. They're giving some very consistent information from what we've already known, but also being able to embed into that ever evolving new things that come down the pike. And I'm sure AI has been one of those conversations that y'all chatted about as well. So glad to hear about those, that information available also from the conference.
Excellent. Well, shall we look to some of our questions?
I would love to. We've had several come in as right from the get-go. Should we focus on to that one real quick?
Dig in.
All right, the very first question. Thank you for getting one out there before we really got into things today, but it was a good one. Please comment on the scenario of providing remote services to a family in which one member of the family is located in a non-SIPAC state. And what's the most common data breach, perhaps in telepsychology? That might
Sure.
be a secondary question, but I think the first one is a great question because not only do we have interjurisdictional, we now have SIPAC and non-SIPAC jurisdictions. So do you want to head us off with that one, Sarah?
Sure. This is a great question because it comes up. I'm going to give you the most risk managed answer, and then I'm going to tell you other things I've heard because I'm recommending them, but I've just heard them. So, the most risk managed answer is we practice where we're licensed, and it's just an oldie but a goodie. So, what I mean to say is either I'm licensed in the place or vis-a-vis SIPAC, I'm permitted to practice into a location. If I am seeing someone and providing psychological services outside that jurisdiction, then I'm practicing without a license and I'm opening myself to greater risk. Now, the thing I've heard, the argument I've heard is like, well, yes, and what if that person, that family member is just attending as a collateral reporter? This isn't family therapy, because I think we could all agree, okay, if it's family therapy, couples therapy, an evaluation where I'm capturing parent report or perhaps an assessment for custody, all of these are circumstances where I am providing a psychological service to an identified person. And I think in those circumstances, it feels less gray to me in terms of, well, I need to be licensed or vis-a-vis SIPAC, have some sort of facilitation, or, excuse me, there are also temporary practices that jurisdictions can permit us to practice for brief amounts of time, as we've talked about in prior chats. Where it gets furry, and the thing I've heard people talk about is say, well, hold on. What if the family member is just coming in and they're just doing a collateral report? And I'm very clear that they're not the patient and we don't have a clinical relationship. And, and I'll just be totally honest, that to me feels fuzzier. I would tell you my opinion on that is I don't love it. I probably wouldn't do it unless there was absolute medical necessity that I thought this was critical for my client's well-being or safety. It's probably not something I would do because I think that line gets a little gray and furry. I know when I have a collateral reporter join a session, I do have them sign something articulating that they understand that they're not joining. I'm not their therapist, but I also, outline the nature of what I do. It's basically a mini informed consent for not having a therapeutic relationship, that this is the nature of the conversation we're going to have. These are the limits of confidence and privacy, because it's not as if that collateral reporter came in and started talking about abusing someone who is a child or an elderly person, I'm still bound by mandated reporting. So for me, I think if we could figure out a way to do it through SIPAC, if we could figure out a way to do it through licensure or through a temporary practice, that would be much preferable. Otherwise, I would probably come down on the side of like, that feels risky to me because now I feel like I'm practicing in an area I'm not licensed. And I want to acknowledge you could find people who feel otherwise. But I think the most risk managed perspective on this would be to just stick with talking to folks in that clinical setting, or it could be, I'm assuming we're talking about a clinical setting from what's being said here, because we're talking about SIPAC, of really kind of staying within those confines of where we have some coverage, our license, a temporary practice permission, or SIPAC. What do you think?
I would agree with you. I think it's lovely that we have SIPAC options if we are authorized to practice through that mechanism. But it doesn't solve the license requirement issues in all cases. And this is a great example question of one of those cases where it doesn't solve that scenario. And how would we do this if it wasn't telepractice? What would we do? How might we gather that information if it is collateral, or what would we need to go through in order to see that family member, if indeed it was a therapeutic component of a family therapy process, what would we need to do in order to practice into that jurisdiction? And so looking at that jurisdiction, at their board, at their website, figuring out, is there temporary practice opportunities there? Is there guest practice opportunities? Or is it a long-term scenario where it would make sense that you might need a license for that jurisdiction? So there are other workarounds. The important consideration, like you're describing, Sarah, is really thinking through what the risks are and how you might go about mitigating those.
Because I can say, this is just a collateral report. We're not going to be talking about that. And let's say it doesn't really control what people do in the session. You know, they could show up in the session and say, oh, well, gosh, he always does this. And they may get into a more emotional discourse. That doesn't necessarily make it therapy, I'm not suggesting, but I'm always trying to imagine it under the lens of a board complaint. So now if I have a board complaint and somebody says, you know, that Dr. Sarah, she had me come and talk to my mother and we talked all about my childhood and that time that this, that, and the other happened, you know, but she said it wasn't therapy, but it sure felt like therapy. You know, if I start to get itchy, then I'd have to defend it. To me, that's a good rubric. But I saw in there in the chat, someone asked, and I want to get to the second part of the question, but if I would share that ROI, please feel free to email me at sarah@drsmucker.com, and I'm happy to share that with you. And I will put that in the chat. Actually, I will put my trust insurance website or email. Additionally, someone asked, what's the most common type of, and how did they phrase it? Breach, confidentiality breach?
What is the most common data breach in telepsychology?
You know,
I had time to think about this while you were talking, so I'm curious what your answer is.
If you've had time to, I mean, I'll tell you this is my opinion. I feel like maybe you Googled it and no. The one I am most aware of, and the board complaints I've sat in on and heard about, you know, in my career, they are not big ones happen at scale. You know, cybersecurity events happen at scale. You know, practices having some sort of breach happen at scale. So they're very impactful events, but in turn, and many people impacted and affected. So from that perspective, we could look at some of those events. But I actually think the question you're asking, and I think the meta point to me is the vastly more common thing that happens is very mundane. It doesn't look like an episode of Hackers, and it's not very high tech. It's really very basic things. So folks accidentally forwarding an email, or, you know, not having a secure password on something, or leaving information, you know, on a personal drive when it really was supposed to be password protected in, you know, in an electronic health record. They're really just silly missteps. I was on an email recently where someone was sending out sensitive information. They accidentally put someone, because it auto-filled the email address. These types of things happen when we use technology. Because, you know, the user errors are frequent. It doesn't mean anything terrible about the user, but to me, it highlights this is why we try to have processes in place and use products designed for healthcare that just have little extra securities. So if I'm emailing with all my clients, it is so much easier to make that error than if I'm using the messaging app internal to my electronic health record. If I'm texting with clients, it is just so much easier than, again, if I'm using something that's through something facilitated for healthcare. I'm not saying we never email with a client or we never text with a client. If we have that as part of our practice, okay, but then we need to acknowledge that additional risk as part of our informed consent and have the conversation. Some people will decide that that ease and accessibility outweighs the risk of, you know, these greater propensity for accidents. But the thing I would say is it's not the high tech stuff, it's the pretty low tech stuff. You know, just in the same way that I've had stood next to a lot of conversations with someone on a cell phone and I'm hearing things I probably shouldn't hear, akin to that. What was your answer, Margot?
That was actually going to be my answer. Is it's probably on the patient side, and it's somebody walking into the session in, you know, unaware that perhaps it's going on, or that the patient isn't concerned that someone else is listening in on the session. And so I view that as a data breach just as much as if somebody barged into my physical office when I'm having a session with a patient as well, and we haven't had a conversation or talked about that. So, and not to say that patients are the breaching side, but it just seems to be a very common experience of, for some reason, the session needing to be a bit on hold while we figure out what's going on in the background or where the patient may be, because they're joining from their car or their office or someplace that we, have maybe had a conversation about not doing before, but we need to have that conversation again. So I think it is those quiet things that on the surface don't necessarily seem all that giant, but really can be that challenging scenario of that data being breached, even though it doesn't necessarily feel that way.
I see a lot of questions about BOI and some specific questions. I'm going to go ahead and put an FAQ in our chat for folks who want to hunt down some of those specific questions. I don't want to purport myself to be a tax expert or an attorney, but we brought it up. So I'd like to provide a resource where folks can see some additional information.
And I did drop an answer to one of the questions in there in terms of what the requirement is in terms of the full name. So it's the Beneficial Ownership Information Report, which certainly you can Google, but Sarah will drop some information in there. Sarah, we had another question about just ideas of what to do if there are disruptions in technology. And, we're obviously seeing a few more of these things happening. It's maybe less understandable or I won't say acceptable, but when we first everybody pivoted a few years ago into telepsychology, it was a little bit more, oh, we'll deal with it. It's okay. We recognize everybody's still learning this stuff. Now we just expect these things to work, and sometimes they don't. So do you have some tips for folks in terms of some of the backup strategies or systems?
Sure. I think it's a great question. And to your point, there was a time we were all just sort of scrambling and, getting through our day. But many of us have adopted a hybrid practice or perhaps a telehealth only practice. And it really is, it's part of the expect the unexpected that most of us can anticipate at some point. I think many of us have sat down and, there's an internet issue, or Zoom's updating or something. So for me, it is predicated largely on what type of practice you have. How often are you using video conferencing? How often are you using messaging? How often are you using telephone to communicate with your clients? And what types of technologies do you use? So I'm going to speak sort of generally, understanding that, you'd want to make it bespoke for your needs, but let's assume that we're talking about video conferencing to a certain extent and other internet-enabled services. In these instances, it's my recommendation, as we were talking about earlier with the CrowdStrike outage, redundancy. It is a worthwhile investment, especially if you have an entirely telehealth or a hybrid practice, to invest in some technology redundancy. It doesn't need to be costly. So for example, I think right now I have 4 different HIPAA compliant video conferencing platforms. That's mostly because I'm a nerd, but I have one that's integrated into my electronic health record. I actually pay for a second one because I kind of like the features. But there's also some nice free ones, so maybe if I don't want to assume an additional cost, I'm just aware of, and I do a little homework in advance of how in a pinch, if there was an outage, through my technology vendor, would I pivot quickly to another one? Would I have it set up so that I'm aware of the link I would need to send to my client? If I think about how I would communicate that, would it be over email? Would it be over messaging, text, so forth? So kind of both a resource and then a process element. What's the resource I would use in case of disruption to my video conferencing vendor, and then how would I get that information to the client in a timely fashion? Often I'll tell you, if I've had the issue happen, I'll send an email, and if it's the beginning of their appointment time, I just call as well, giving them the link to the alternative platform. Now, none of that really matters if you have no internet, which is a very common issue. I'll tell you, in my household at any given time, and this was something born out of necessity from the pandemic, we have 2 internet service providers. It's not delightful paying the bill, but I will say it makes our lives go easily because we have 2 people who work from home. We have a young person who enjoys, well, I was going to say enjoys the internet. She does her schoolwork, but I don't know if she enjoys it, but she needs to do it. So, we're using it in many ways. So I think there's some value in having some redundancy. Some folks will, that's an expense for us. if you don't want to necessarily assume that much expense. There are less expensive, you can typically pay for hotspots, from your mobile carrier. We'll give you an option. Many of us have tethering available from our mobile device that we're able to connect and have some redundancy for our internet. If you do that, just make sure that you are doing it in a way that is password protected and not inviting everyone and their brother to hop on your network, even though you may be a lovely and generous person, because it just impairs the security.
And I think as one other follow-up, I will say to this, just because Verizon's down or Microsoft is having a challenge or whatever your provider background is not functioning well, that is not a reason to move to something that is not HIPAA compliant at that moment. And so I think making sure that you've got some strategies in place, similar to maybe your emergency policy and procedures that you talk through with your clients. If for some reason some of the technology's down, here's kind of what the structure might look like, or a place that they could point to if they can't reach you or communicate with you as well.
Great point. I mean, when push comes to shove, sometimes you just have a phone call, and that's okay too. But to do that in advance, we need to have discussed that that's what we would do. And I would need to have explained to my client, well, we have a phone call that might be reimbursed at a different rate. So it's just these types of like informed consent things where, what is it? Anyway, I'm failing my idiom test, but being well prepared will help us in the future. Something about offense and defense, but I'll leave it there.
Measure twice, cut once.
Well, should we go on to our next topic from last time?
Yes. Well, I was going to bring up the stumper question that we had really quick, because we had a question that came in our last live chats that I recognized is a really good one, but not something to dig into right that day. Because we needed to find the answer out. And I think we have actually, it was kind of like stump the band kind of challenge here, but I think we've blown Sarah's mind in what we have discovered in the answer. And so here is the question. If a provider does not take insurance, what HIPAA requirements or obligations are they beholden to? And this is one that initially from the start, we might go, oh, everybody's beholden to HIPAA and you have to follow all the HIPAA requirements. And it's really intriguing as we've dug in, and we actually reached out to our risk management counterparts just to double check on this. And so a shout out to Dan Taub for helping with some of this clarification. We're beholden to HIPAA as soon in our practices that we might step into having any type of interaction with insurance. Now, for many of us, this actually could happen in training or on an internship, or it might never actually happen for us. But the day it does, we become a HIPAA beholden entity. And so if you're one of these lucky folks who has never had an interaction or a transaction or a call to an insurance company to see if any of your patients may have been covered or had some type of healthcare policy in place, then you may not be a HIPAA beholden entity. It's probably a very rare circumstance because anytime you engage with an insurance company for the purposes of a patient, using a digital or a technological device, including the telephone, that would constitute you becoming a HIPAA-related entity. So those interactions are defined as things like transmission of healthcare claims, payments and remittance advice, healthcare status, any authorization or pre-authorization for treatment. So if that patient has insurance, but you're not covered and you've called to clarify that, that has stepped you into a HIPAA entity. Coordination of any benefits or eligibility check or enrollment check, or any referral or certification or authorization from insurance or for the purposes of transacting that business with insurance. So it's probably very unlikely that there's somebody listening to the telehealth chat that would not fall under HIPAA, but there are a few little pockets of providers who I think have somehow managed to escape this lovely field of HIPAA requirements. But once you have engaged somehow as a HIPAA entity, even if the rest of your life you might be practicing in private pay, you are still beholden to be beholden to the requirements of HIPAA. So I am going to guess we're going to get some further clarification questions on this. And my recommendation would actually be if you feel that you do not fall under the HIPAA requirements, that you actually call our colleagues in the risk management advocate program and discuss your particular situation and circumstance with them to have some clarification.
I saw we had a question saying, so once you're a HIPAA covered entity, you are always one. And that was, so there's so much about this blew my mind, which as I was telling Margot before the chat started, I think this poor reading comprehension on my part, it has insurance in the name, HIPAA, but how tethered it is to electronic activities around insurance. Yes. So Dan Taub assured us that it may extend beyond our deaths as well. Just kidding. But, yes, it really is the case that even if I, let's say, and this is the case, for me at various times in my practice, there have been moments where I've been private pay, there are moments where I've taken insurance. And the idea is, yes, once you've engaged in that activity, that it extends forward. And the fascinating thing to me as well that Margot highlighted was I could maybe be a private pay practitioner, but if I did some of those other activities like checking eligibility or, some of those other things, it still triggers it. So I thought it was incredibly fascinating. We're going to keep getting more information on this because this just we thought this was a great question, total stumper. And I would encourage you, if you're sitting here listening, thinking, I think I might just be not, make that call to the advocate service and ask those risk managers because they have depth understanding of this. And you can get quite granular saying, these are the specific activities I do. And let's look at under the lens of the law. They're not attorneys, they're not doling out legal advice, but they can give you some really good guidance to get you started on that path.
Yes, I know this is one we'll be bringing back up.
Yeah, I'm sure. Yeah, this one kind of blew my mind. I was just like, wow.
We have a couple other questions, but should we move over to some information about psychopharmacology and telepractice?
Do that and come back to those questions because that was a really good as well.
Yes, and we've had this question come up a few times, and we've talked a bit about it, but thought maybe it's worth a bit of a segment to just dive in a little bit in terms of psychopharmacology and telepractice. And the prescriptive authority movement in psychology is really burgeoning. We know that we've had these conversations, not just with our patients, but also with our referring colleagues in terms of, how we can better serve our populations. And from that, we've had some really awesome supplemental education and clinical pharmacology programs that have come along. And this particular question is very specific to those who have come through those programs and have permission to practice as a psychologist with prescribing rights. And so there are 7 states that currently allow psychologists with that training to be registered and or certified or licensed within their state to do this type of practice. They are New Mexico, Louisiana, Illinois, Iowa, Idaho, Colorado, and Utah. And we also have the Public Health Service, the Indian Health Service, the U.S. military, and the U.S. territory of Guam that are covered within those different jurisdictions. Now, legislation has been proposed in some other states and is ongoing and kind of moving along. But those are the states in which folks have the ability to train for and become licensed or certified, depending on the jurisdiction, to have that prescribing privilege within that jurisdiction. And I think that's a really important thing to emphasize here, because as we're talking about telepractice, we are not talking about interjurisdictional telepractice of psychopharmacology. And I think that's a really important consideration here that we make very clear, that there may actually be telepractice requirements within each of these jurisdictions in terms of what people, what providers can do and how they practice psychopharmacology, whether they can do that through technology or telepractice, or whether they have to see those folks actually in person. That is going to be jurisdiction dependent, but for sure it does not cross jurisdictional lines, and it does not at all apply to those with a SIPAC credential. So talk more about that in a moment. What we have estimated is there's probably in the entire US 250 or 300 psychologists who actually have prescribing privileges. So even though there's a lot of news out there about it, there's a very, very small group of folks who are able to do this, which in itself is a little bit
Oh, that's fascinating. Like, as much as it gets talked about, I was ready for thousands upon thousands, and it's really a
yeah.
small cohort. But I mean, and they're gonna be kind of the pilot, for like how this goes, and how the profession engages around this thing.
Exactly. And we
Okay.
know, I mean, that whole entire area of practice has come about because of some of these um, medical deserts in terms of both access to care as well as, folks within the community able to see the volume of folks needing this type of intervention. But it's really key to understand that even if you do hold a SIPAC, um, authorization to practice, that it does not extend to prescriptive authority. And so making sure that even while you might be able to do that within your home state, you're certainly not able to do that outside of that jurisdiction. And also being very cognizant of rules specific to telehealth prescription and controlled substances. We know there's a lot of these things that are changing in the past several years. And we've talked about some of those things on previous chats, but
Yeah.
really recognizing if you are SIPAC and you don't hold a prescription privilege, what you are able to have conversation or recommendation about to patients across jurisdictional lines. So it even if even if you're not one of the 250 or 300 psychologists, you still are likely asking folks about what medications they're taking and being very cognizant about what you may recommend or how you may talk about those within your interjurisdictional practice is really important to consider.
And I think, we're living in this moment where awareness of some of these laws and the public health protections is valuable. I've had a circumstance where someone's reported to me that they're receiving their medications in ways that don't sound quite right. And there is a lot of legislation regarding telehealth prescription, especially around controlled substance. But even the question, it's been an open question in the context of COVID that's waxed and waned, but does a telehealth prescription trigger the necessity for in-person medical assessment? That was actually something waived in COVID that has since been sustained, but it's an open question. So I think, when I hear a client tell me, oh, I got my antidepressant and I did it on a bot, through this website. Like, I have a lot of questions regarding sort of their public health and protections. And so I think having some awareness, even if I have no intention of ever being a prescribing authority, I think there's value.
Yeah. And I think it's that awareness of asking the questions and really understanding that if you get nothing else out of our telehealth chats, the one thing I do hope is that you realize how each jurisdiction works is slightly different, and that the rules, even in psychology or medicine or pharmacology, are different across different jurisdictions, and we really have to be at least knowledgeable of that fine point, and then we can start to ask good questions about how we can serve folks if they're going out of state or are out of state in terms of what that practice looks like for us. All
Shall
right,
we
Sarah,
talk
should we
about the
come
next
back
week?
to the live questions or?
Yeah, I saw one in there that's like, any chance I get to talk about business associates agreement, I want to. And so there was a question there, like, oh, yay. Someone asked, according to their customer service, Microsoft or Microsoft Office 365 offers encrypted email with the subscription. I'm aware of that too. That's the one I use as well when I want encrypted email. But how would I know if this is HIPAA compliant? It's a really great question. And to me, it brings up two separate buckets. One is literally what is the signaling mechanism that says they are going to be a good business partner to a HIPAA covered entity, assuming, as previously discussed, that I am, which I think I am, frankly. But we want that BAA, that Business Associates Agreement, which is an agreement that a company vendor signs that says, hey, we understand that you, customer, are a HIPAA covered entity, and we're going to follow the rules of HIPAA to make sure we don't get you in trouble. So that's the document we want. We want a business associates agreement. Many entities like Google and Microsoft, they will have it automated in a way that if you poke around their website typically, or if you go to their customer service, certainly, they can trigger that without too much trouble. Personally, if I went to a vendor and they were like, a what now? And they hadn't heard of it and they were hemming and hawing, I would be less enthusiastic to work with that vendor because I want to be a normal, boring, average customer for them. I want to have the concerns of normal, boring, average customers. So there's that one piece, but I also feel like, maybe I'm inferring too much, but I feel like the second part of the question kind of was like, let's say they give me the BAA. How do I know they're doing it, right? Like, has there been really notable public examples where companies that offered BAAs, they were saying, yes, we're HIPAA compliant, there's some problem. They do something inappropriate, or maybe it's something that's not their fault if there's a breach, but maybe they don't handle the breach well. We've all seen in the news things happen where things go suboptimally. And this is where I think we do our best. We're not trained as technologists, we're trained as psychologists. We read the fine print, we're curious, we ask questions, we ask for the BAA. And I hold all of this lightly. Like, as a consumer, I appreciate that I am not adequately technologically savvy, that I'm going to see every signal of an issue, but I try to catch those things that I, as a more of a layperson, can catch. I click through that long, annoying agreement that they make me sign and ask, what are the user terms? What am I agreeing to? I make sure that I read through that BAA. What are you saying you're going to do? And if I see any questions or concerns, or things pop up, new features, I think a lot of these products that are designed for telehealth have a lot of AI-enabled features. I don't hesitate to send an email to customer service and say, hey, I see now that you're offering, let's say, for example, AI transcription. Where do the transcripts go? I want to know, and I'm not shy about asking the question. So those are the types of things, we do our best, and that's what I would say. Not the best, most satisfying answer, but I'd say get that BAA. And then we do our best and we're curious, we ask questions and we read the fine print.
Yes. And I think that really is the key to, if you don't understand it, to ask more questions. And I love the idea of you can call or email with customer service to ask that and get some documentation and get some better details so that it helps you make a good decision as to whether that's a vendor you want to work with or not. So I love that. Sarah, we had a couple questions from the last chat that we could go back to if you think.
Please.
All right. One of the questions had to do with how you describe yourself or maybe market might be another way to think of it. If you are somebody who holds a SIPAC credential, for example, do you say I'm licensed in 42 jurisdictions to practice psychology? And I think the authorization to practice interjurisdictional telehealth or telepractice or telepsychology is the certificate that you get through that SIPAC process. And it is authorizing you to practice interjurisdictional telepsychology. It is not giving you 42 licenses to practice in each of those jurisdictions. And I think it's a very subtle but very important distinction, because you do not want your patients or clients to think that you may hold an actual license from each of those jurisdictions, because that's not in fact what the process is or what's going on. Now, you may hold multiple licenses. You may have several states that you're licensed in. I would suspect it's very few folks who actually hold a license in 42 jurisdictions, because that would be a full-time job to keep up with. Although I'd be interested in chatting with those folks, because there are quite some interesting processes for that licensing. But that's the whole point of the SIPAC, which is a process in which you can be authorized to practice without having to go through the licensure process. So just a subtle clarification, but a very important clarification. And we had another question about which state laws would prevail for duty to warn and protect if a client and a therapist are in different jurisdictions? So, for example, if one's stricter, do you follow that? Or in a few scenarios, you could actually find where the law is silent on duty to warn. And if you happen to be licensed in one of those jurisdictions and that's your home jurisdiction, you are going to find it very difficult to figure out how to address these conflicts in law when you might be practicing and your patient is in a jurisdiction in which it says you must warn somebody, for example, in child or elder abuse or suicidal or homicidal situation. And so we always fall back on our recommendations for thinking through these things before you get into the situation, to contemplate, wow, how would I negotiate this? Or maybe I need to make a call to the risk management advocates group to figure out, how do I navigate this? Because you do not want to find yourself without immunity, having made a call to do some type of welfare check in a state in which you do not actually have authority to either breach that confidentiality, or you're not protected in your practice of doing so. And again, you may still choose to do that if you feel that that's in your best interest and the patient's best interest. But you want to have all of that documented for if or when something might come about from a complaint or a concern that's raised for your licensure. So you do need to have different paperwork if you're serving folks in different jurisdictions. That paperwork needs to be relevant to that jurisdiction, not just any other jurisdiction. And when you are working through SIPAC and you're seeing someone in another state, you need to know what the obligations are as a provider within that other state. You may have some income tax obligations, you may have some other requirements that you are beholden to. And so doing your due diligence to determine all of this before you get into the situation or into that client-patient provider relationship, you really want to find that out and allow your paperwork to help navigate that process for both you and your patients.
I think this is a great point, and especially if you have a practice where you know routinely you're going to have an interjurisdictional practice. So some of us may live on the border of two states and we just routinely see folks between those jurisdictions. Anytime it's predictable that this is going to happen, we want to contra-distinguish our documentation for those circumstances and make sure either we have special documents for that or it's included, as a contingency in our informed consent, but we're telling folks in advance, hey, here's the law here, here's the law here, this is what we're going to do. And that we're really transparent with folks. And to me, informed consent is, yes, it's a paper, but it's also a process, right? So there's this document that we get signed, but then there's also the conversations we have around it. And to me, that's a really central part of that, is talking through what to expect. I recall years ago, a survey that was done examining the most common reasons that complaints were brought against psychologists. And so much of it had to do with the violation of expectations when things didn't go the way a client or patient thought it was going to go. And so to me, there's these opportunities, especially, I'm not talking about the catch as catch can of like, oh my goodness, someone's calling me, they're in another state. What am I doing? But no, I knew this was going to happen, or perhaps I've even committed to doing it in the long term. In those instances, we have the time to research, document, and discuss in advance. And it's an extra investment of our time and energy, but one that really pays dividends if something happens in the moment and we're not left, stressed and scrambling.
And I think it really, to me, all comes down to some of the aha moments that I have recognized in my career where, as an undergrad and a grad student, it just was kind of, the curriculum was such that this is how it all works and everywhere it works the same. And that really is not the case, that each jurisdiction has its own nuances. And being aware of those and helping your patients understand that as well, and helping have those conversations of, what are the boundaries of this relationship and what are the processes and procedures that we might use if we have to navigate some of those things as we go. So we've had a lot to chat about today, Sarah. I have loved the information that you shared in terms of the new guidelines, and I know we'll continue to have some conversations about those. We've had some high-level discussions about what's coming up in some of those revisions, and hopefully folks will kind of take in and dig into that. And also we've talked about the psychopharmacology and telepsychology and a ton of really amazing questions. And I know there's more that we will gather from this chat and bring to our next one. So super thrilled to see you the next time. But do you have anything to close us out before I finish off with our extras?
Not today. I really appreciate always this time with you, Margot, and I appreciate everybody who came and spent their time with us today. Your questions make for just richer discourse, and we really appreciate it.